Good morning, everyone. This is Ryan Morgan and Andrew Frisch from Morgan & Morgan. We are about to kick off the webinar here. We'll give another 45, 60 seconds just to see who else can join, and then we'll get started. Please feel free at any point in time to use the private chat buttons on this and send us either questions or any other items you may want to send. We do have someone monitoring that as well, and you do have the capability to send that privately just to us. Okay, let's get started. For anyone who has just recently joined us, my name is Ryan Morgan of the law firm of Morgan & Morgan. My colleague and partner Andrew Frisch is also on the phone here, and this webinar is to discuss AML BSA analysts. We have had quite a bit of experience handling those types of claims over the last few years. And so this webinar will sort of discuss those claims in general and what types of cases we typically see and what we are able to typically do with those types of cases. Now, a moment ago, and for anyone who had recently joined, there is a private chat function where you can send a private message to myself or Andrew or also Caitlin, who is our marketing manager here, and she is helping put this webinar on. You can send a private message to us, and please remember that that is an attorney-client privileged communication, even though you have not hired us or anything like that, but any sort of communication which may ultimately end up as an attorney-client relationship or not is privileged. So remember, anything you send to us, as long as you're sending it to us privately, is a privileged matter. It will stay that way until you decide to proceed with any sort of action or anything like that. But a little bit of background about who we are. Again, as I said, my name is Ryan Morgan, and along with Andrew Frisch, both of us together run the employee rights group for Morgan & Morgan. We have approximately 20 to 25 lawyers in our department alone who do just employment cases, ranging from a wage and hour case, like we're going to discuss here in a few minutes, involving unpaid time, to discrimination claims, FMLA claims, retaliation, whistleblower claims, anything like that. We do these cases all across the country. I myself am licensed in multiple states. Andrew is licensed in multiple states, as well as in New York, where a lot of the financial services sectors are located. I have been doing these types of employment cases for over 10 years now, I guess 11 years technically. And I've handled thousands of cases. I have handled multiple, I'd probably have to say over 50 class or collective action type cases involving unpaid wages. Andrew and I have worked on numerous, we call them the AML, the BSA cases, where it's the type of analyst like you guys are, performing work for banks and other financial institutions. We've probably handled at least 20 to 30 years worth of, 20 to 30 cases of AML, BSA type cases alone. And Andrew, I'll let you chime in with a little bit of your background.
Sure. I'm almost a 20-year lawyer. Just like Ryan, I've been handling employment cases for 15, 20 years. More recently, our practice has been focused on unpaid wages cases, unpaid overtime, unpaid minimum wages. And in the last few years, because of the Patriot Act and the explosion of consent orders that we've seen in the industry you guys are in, and the amount of overtime that people work, it's typically not properly compensated. we've had a lot of cases representing AMLs, BSAs, KYCs, and people like yourselves for unpaid overtime. We've sued some of the biggest banks. We've sued staffing companies. We've sued banks and staffing companies in the same cases, and we've had a lot of success because under the law, we believe that virtually all of you guys are entitled to overtime. And I think we think the law is fairly clear on that, but a lot of employers ignore it.
Okay, so what we're going to talk about briefly here today is, as we've just described, are you owed money? Are you a victim of wage theft? And just so we're all on the same page, I think we all are, but with the monikers that we have here, AML obviously would be the anti-money laundering aspect, KYC, the know your client, know your customer aspect, and BSA, Bank Secrecy Act. I know different banks and different financial institutions use typically some sort of combination of those different names, but really what it's covering and what we're talking about is anybody in this industry doing the type of the due diligence and the other information gathering and the kind of usually typically first and even second level investigations into typical money laundering issues. And what we want to discuss is, are you being properly compensated? Are you protecting yourself from being taken advantage of? And at the end, we'll have a special offer here that we've hinted at already a little bit, but we'll discuss that at the end of the webinar here. So we typically see two types of cases in this area. The first case would be you're working overtime and you could be paid a salary or you could be paid by the hour. And you don't get overtime. You are just getting your regular salary or you're getting straight pay, but you're an employee. You are an employee of the company that you are working for. In those situations, what we look at as the lawyers is whether you are an exempt employee or not. If you are exempt, you don't get overtime. So from our perspective, and to have a claim, you want to be non-exempt. Now, there's some exemptions that come up here for some of the higher level employees. If you're supervising employees and you're hiring and firing and things of that sort of lower level employees, you can be an exempt manager. But typically what we are looking at in these types of cases is it's called the administrative exemption. If you Google it, you will find more material and information than you probably care to read on the administrative exemption. But what it really boils down to is among the various elements the company has to prove to show they don't have to pay you overtime is that you yourself were exercising significant discretion and independent judgment in your job duties. And that's where a lot of these cases will rise and fall is, as you know, this is a very, and Andrew just touched on it, this is a very regimented area of the financial services sector with lots of rules, lots of regulations that you must follow, not just from the federal government, but even from within your individual bank or financial service. If something happens, you must do this. If something else happens, then you need to do this. If you see this fact pattern or something comes up, you must escalate it to the next level up. There are regulations from the Department of Labor that say, in essence, paraphrasing, that if you are using well-established techniques and in essence kind of following a playbook, a guideline, a policy over and over again, that is not discretion. That is not independent judgment. Doesn't mean what you're doing is not important. Of course, it is very important, but it doesn't satisfy the administrative exemption where they can then, these companies claim properly, you are exempt. So that's kind of case number one that we see quite a bit. And Andrew, I'll let you handle case number two.
Sure. Case number two is very similar to case number one. The biggest difference is that the employer or employers, rather than paying you as a W-2, they unilaterally classify you as an independent contractor and give you your wages through a 1099. Really, it's not significantly different. You're still an employee under the law. It's just that the employer is calling you a contractor. They're still controlling all aspects of it, just like Ryan was just saying. They kind of have to, because they have to make sure that all the files are being reviewed in a uniform fashion for the same reasons that you're reviewing them in the first place, and that the reviews are completed in a standardized way, and that if appropriate, an SAR has to be complete or something like that at the very end, that's being done. And so there's necessarily complete control over your work, so that even if they call you an independent contractor, you're really an employee within the meaning of the law. And the most thing that we see is they pay you hourly. They say you're an independent contractor. And regardless of your hourly rate, if they're paying you $50 an hour, they're paying you $50 an hour for hours 1 through 40, meaning the non-overtime hours. And then when you work over 40, which is the overtime hours each week, they're paying you the same rate, or the same $50 in this example, for your overtime hours. And in those cases, you should be paid time and a half rather than simply straight time, or $75 in this example. And when they don't pay you the time and a half overtime, that's where the claim arises under the law.
So what can we do? How can we help you guys? Now I touched on it earlier. We've handled numerous similar cases in this industry. If you go to Google, or you are savvy enough and can search around the PACER docket, which is the federal court system docket, you can see our cases. We can't necessarily talk about them right now because they are privileged matters with our clients, but it's public record. So do your own research, look into us, look at the cases we've handled against some of the biggest banks in the world, and have been successful. Knock on wood here. I can't think of one AML BSA case where we have not prevailed and recovered money for our clients. Now, about Morgan & Morgan entirely is, like I said, we have about 25 lawyers in the employment arena, but our entire firm has almost 500 lawyers. We are a very large firm, which is important because we have the financial wherewithal and the backing from the firm to go toe-to-toe with the biggest banks in the world. Our firm is not afraid to take the long view and take the long fight if that's what it's necessary to win. We handle these cases entirely on a contingency fee basis. So you are not hiring us and then having to write a check for whatever amount of money to hire us, or a cost deposit or anything like that. We only get paid if we prevail and if we recover money for you. A question we get a lot from individuals, especially in this industry, because we understand it's a fairly small niche industry, is retaliation, being blackballed. I completely understand that. So far, again, knocking on wood here, I do not recall any individual which has truly suffered from this. And I can tell you, I've also had numerous repeat customers, for lack of a better term, of clients who have had multiple cases with us. Clearly, they've been able to find new jobs and find new work in the industry, oftentimes being paid the same way that's illegal, and then come back to us to recover their properly owed wages. So certainly, if it came up, we would absolutely help anybody with any sort of retaliation aspect that is happening. This is kind of as a recap here of what we were discussing a little bit ago, is the misclassification. That's what we talk about. That's the formal legal term, if you want to go look all this up yourself, about whether you are an exempt or a non-exempt employee. And like we said, the biggest, most common exemption that we see that these companies and the banks try to allege is the administrative exemption. Same thing with the independent contractors, treating them as salaried employees or even hourly employees paid straight time. Knock on wood, so far, again, have been successful in all those independent contractor claims where we just have to prove that you were an employee in addition to the exemption status. Now, how do you protect yourself? I will tell you one thing that that you can do, even if you're not ready to pursue a claim, or you really don't even want to pursue a claim, but you just say, how can I help myself? Make sure you are tracking the accurate hours you are working. Now, if you're being paid by the hour and being paid that straight time by the hour, that's great because that sort of tracks itself. But if you're being paid a salary, or maybe you're not being paid for all the hours you actually work, they only allow you to be paid on the quote billable time, and then the unbillable time you don't get paid for, keep a log. It doesn't have to be anything sophisticated or fancy. You can have a yellow pad that just every day you write your starting and end time. You can create an Excel spreadsheet, something like that. But those are very helpful later on in our cases where we do have sort of a discussion and a fight about how many hours somebody worked. It's great that somebody has kept contemporaneous evidence that we can then throw back at the bank and the employer and say, hey, here's what so-and-so worked, prove them wrong. Prove them wrong. So that is certainly the one way to protect yourself. And then the other way, which kind of leads into our special offer, is contact an attorney. Remember, these are confidential, privileged communications. We can't tell anybody about them. We're not going to tell anybody about them until we've talked about it, determined you have a claim, and then say, hey, here's what we're planning on doing. We're going to send a letter to the company. We're going to file a lawsuit, whatever the proper course of action is, and you give us that approval. So I have numerous cases in this arena where we've been hired, but we haven't yet contacted the company. We're still assessing and gathering information, getting other people who work there as well to get involved. There's sort of the strength in numbers mentality. So here, for our special offer is, if you will send your email privately to Caitlin, and there's an option when you hit the chat to send it to Caitlin. She will record all those emails, and either myself or Andrew will contact you privately and discuss any situation or just questions you may have, whatever it is. And we can try to answer anything questions you have, or any other situations or issues you want to discuss. I want to say thank you to everybody who has attended here, and hopefully you've learned a little bit. Again, if you have any questions or anything like that, do not hesitate to reach out to any of us here. If you've enjoyed this webinar and you think others would find it useful, please don't hesitate to share it. And I hope you have a good rest of the day.
Thank you.